Good afternoon. This is your air passenger rights update on November 22nd, 2020. My name is Dr. Gábor Lukács. I am the President of Air Passenger Rights. Today we are going to talk about the class action where there was a certification hearing on November 2nd and 3rd earlier this month. We are going to also talk about a BNN poll, a Bloomberg News poll, and a big chunk of our discussion will be about chargeback under provincial statutes, under provincial laws, and what to do if a flight booked with vouchers is cancelled. I'm waiting here to bit of feedback, but I can see that people can hear me, people can see me, so we are going to start right away. First of all, I would like to thank our volunteers, Dominic, Martin, Christine, and Terry, who have been helping to sustain this group, to answer many questions that have been arising throughout the past number of months since our last live broadcast. I also would like to thank Frank Whitestone, who has been immensely helpful in the preparation of the statutory chargeback guides, drafts of which you have already seen, and we are going to talk more about that down the line. The class action that we are talking about is the one in federal court. It is against the 5 major Canadian airlines: Air Canada, Sunwing, Swoop, Air Transat, and WestJet. The class action is currently called a proposed class action. At this point, the court has to decide whether to permit the case to proceed as a class action. What you need to know when we are talking about class actions is that the class action is a procedural matter. It's a question of form, how a particular procedure is going to proceed. And some of the considerations the court is looking at is whether the court has jurisdiction, whether this is actually going to save time for the court. So the court will want to see a list of common issues, wants to see some commonalities. Just because everybody is pissed at the same airlines, that's not enough for a court to grant a class action proceeding to certify. The court will have to see that there are common issues that are common to all the passengers, all the victims, and that resolving some of those legal issues in a class proceeding is going to help to save the court and the parties having to argue each and every case separately. Because the alternative to a class action would be that each passenger would individually sue the airlines, and there would be thousands or tens of thousands or hundreds of thousands of individual legal cases, which would really not be in the interest of having a functional legal system. It really bogged down the legal system. So that is what the issue is going to be, mostly at the class proceeding. And what happened so far was that on November 2nd and 3rd, the federal court, a judge of the federal court, heard a certification motion. So what is being decided on a certification motion is whether a class action is a suitable procedure, is a suitable way for proceeding. It is not about whether the case will eventually prevail, but rather it is one about process. Air Canada was arguing 2 points. The first point Air Canada was making is that the court should not certify the class action in federal court because Air Canada and the other airlines too believe that the court has no jurisdiction. Jurisdiction is the question of whether this type of dispute belongs in the power of the court to resolve. For example, a court in Nova Scotia may not necessarily be able to resolve a dispute that took place entirely within Alberta and has nothing to do with Nova Scotia. In the case of federal courts, the additional aspect is that the airlines were arguing is that the federal courts are statutory courts. Their jurisdiction, their power is prescribed by statute, and they were arguing that these class actions should all be going to provincial superior courts because the federal court does not have jurisdiction here. The federal court does not, there's no specific law under federal statute that the federal court would need to apply, and therefore the federal court cannot get involved. That has been the argument. The second argument that the airlines have been making is that the issue that have arisen is so inhomogeneous, so uncommon to people, that each passenger's circumstances so much differ from each other that it is not suitable, not feasible to deal with the matter through a class action. That argument has also been addressed, of course, by the team of lawyers representing the passengers. The most important bit of update about the class action is that the judge promised an answer, promised a decision by the end of this month. So by the end of November, we should be seeing a decision coming from federal court one way or another. The question is, of course, what the decision will be, and there are several scenarios that we can now explore. Of course, the best scenario is that the judge rules that yes, the federal court has jurisdiction and the case should be certified. So we have to also explore what happens if it doesn't happen. If the judge says, no, we don't have jurisdiction, then that begs the question, who does then? Will it then go to provincial superior courts? If it does go there, then hopefully the similar claims that are being raised in federal court would proceed in provincial superior courts. Although I also believe that federal courts are the most suitable to deal with this type of issues. The other possibilities that the court says, yes, I do have jurisdiction, but I agree with the airlines that there are no sufficient commonality of issues. That is also a troublesome situation, but in either way, whether it's jurisdiction or it is the certification of the case, there is an appeal. So whatever the judge is going to rule, there is a right to appeal to the Federal Court of Appeal and then to the Supreme Court of Canada. And my instinct is that probably whatever decision there may come out from the court at the end of this month, one of the parties will appeal. If the case gets certified, I am quite confident that the airlines are going to appeal it. If it doesn't get certified, I would anticipate that the class counsel, who represents the class, is going to appeal it. Of course, I cannot speak on their behalf, but that would certainly be my anticipation that they would be appealing it. So the bottom line is that it is very important what we are going to see happen in about 8 days from now. But a negative outcome does not mean the end of the road. It does not mean that, oh no, God, we will never see our money. Even if the outcome will be negative, and I don't know what the outcome will be, I just would like to make sure that we are all ready for that possibility. Even if there's a negative outcome, it just means that we have to work harder. We may have to go to a different proceeding, Federal Court of Appeal, possibly provincial court. So it doesn't mean that your money is lost. The best case scenario, which I'm hoping for, and legally speaking, I think there is a strong case for it, is that the court will find that there is jurisdiction and that the case should be certified, because really the question of refund is very common to all passengers. Yes, there may be some nuances, but the basic legal points, the legal obligation to set out terms and conditions with respect to refunds is right in the air transportation regulation. The obligation to have reasonable terms and conditions in the Canada Transportation Act and the air transportation regulations, both of which are federal legislation. So all this point that the airlines were trying to make about jurisdiction, I was not particularly impressed with, although I must say that the lawyer for Air Canada, there was a lawyer, a female lawyer, in terms of showmanship, I was truly in awe about how she presented. Just the deep ethical outrage that she displayed. How the passengers dared to ask for those refunds. Why are they bothering those poor airlines? I thought it was very, very impressive. She definitely did a good job in terms of advocacy for her client. That has to be acknowledged. I'm seeing here already a comment. I would personally, Carmi, not accept vouchers, and I don't think that things have changed in any way about that. Passengers should not accept vouchers because passengers are entitled to a full refund to the original form of payment. That has been the law and it remains the law. In terms of our next item, because this pretty much concludes my comments on the class action, there is an interesting survey that the BNN, the Bloomberg News, put out. I would like to show it to you. And it concerns the ongoing discussion between the government and Air Canada and other airlines about a government bailout, which is a quite good thing in the sense that the government at least made it clear now that the airlines will have to provide refunds if they want to have taxpayers' money. I think that on some level it is still troubling that they will refund people only if they get public money, but it is a bit of progress. Air Canada, in a way typical to Air Canada, I guess, has been taking a very combative position and has been arguing that, well, just give us the money and we are not going to give anything back to the public in exchange. So Mr. Romanescu has been vehemently arguing that having some kind of government stake, in other words, the public owning a portion of Air Canada, would be a terrible disaster for everybody. And I can imagine it is not a good news for his shareholders, but certainly it is great news for the public if it happened. And so BNN put out this survey asking people to comment whether the government should demand a stake in Air Canada or a board seat in exchange for aid. And I certainly do encourage everyone to clearly answer yes to this. I'm going to also post here the link in the chat, and please take a moment to click on a resounding yes there. In terms of the negotiations that are ongoing between Air Canada and other airlines and the government, I confess I don't have many details. I don't know much about that. It will be an interesting process to see whether the government is actually going to force airlines to provide refunds, or whether it will be just, as it has often happened, just some kind of smoke and mirrors, and then passengers get shortchanged again. I'm sure you know, and we have discussed it before, the most important move in terms of politics is Bill C-249. That's a private member bill by a Bloc Québécois member of parliament that seeks to clarify further the law that airlines must provide refunds regardless of the reason for the cancellation. That is a private member bill by Mr. Barcelou Duval from the Bloc Québécois, and it is a declaratory legislation. It declares that regardless of what may be in any other law anywhere else, if a flight is cancelled for reasons beyond or within its control, nevertheless, they must refund passengers the cost, fees, charges, and taxes that the passenger has paid for the air service not received. This bill has passed first reading, and now it is waiting for a second reading. It can provide perhaps some incentive for the federal government to put pressure on the airlines, because it would be quite an embarrassment if it were actually an opposition party forcing what the government's job would be. So we are very grateful to Mr. Bourseau-Duval, and we are looking forward to the support from other members of the opposition to ensure that Canadians get what already they are owed. This bill does not accomplish something new in the sense that it does not create new rights, and that's the importance of it, because especially in such a situation when we want to achieve legislation quickly, that's not really the best time to add new rights. And we are not asking for anything new that we don't already have. All this accomplishes is the right that we already have as passengers, which is a refund for flights that are cancelled if the airline is not able to provide the services. I'm moving back on to the issue that is on the agenda, which is chargebacks under provincial statutes. We have covered this issue many times, and I would like now to do it in a perhaps somewhat more organized way. I would like again to thank Frank Whitestone for his immense contribution of creating the draft guide with the legislation that we have collected before. It has been a very tiresome writing process, with each province taking several days, if not a week, to ensure that things are coherent, that we have all the links to all the legislation. And where I am now with it in terms of the website is that we began to actually migrate the Google Doc type of document, which you have seen before, to an organized website format. So I would like to use that as a way to answer some questions that I'm sure many of you have been asking. And so without further ado, I would like to show you what we already have in place for Ontario. This is the chargeback guide under Ontario statute. This is a website. This is our own website. The link is not public yet, but if you desperately need a link to this document, even though it is still being reviewed, I'm happy to send it to you over PM or private messaging. So we are going to use now Ontario to go through a concise summary of how chargebacks work, what is chargeback about, and how you go through the steps of a statutory chargeback. So the first thing to know about a statutory chargeback is that it is guaranteed by statute. So let's just have a look at this information here as well. It is already on the website. So a statutory chargeback is not the same as going through your card issuer or bank's internal chargeback process. That is something you have done before probably. And the good thing about statutory chargeback is that you may go through statutory chargeback even if previously Visa, MasterCard, or American Express turned you down before. So the statutory chargeback process, because it is independent of the bank's own rules, as a result, the statutory chargeback process is something that you can do regardless of what happened previously in your communications with the bank and or with a credit card. The statutory chargeback is a procedure guaranteed by your provincial statutes. So in the case of Ontario, it is guaranteed under the Consumer Protection Act of Ontario and the general regulations that were made under the Act. What triggers the right to a statutory chargeback in Ontario is that you did not receive services you purchased under a future performance agreement. A future performance agreement is an agreement where the performance is in the future. It is explained in greater detail down the line. So there are two preliminary elements to trigger the right to statutory chargeback. You have to have a future performance agreement, and you have to have a situation where you didn't receive the services that you paid for. In terms of the first step, because this is a three-step process, first of all, you give a notice of cancellation of the future performance contract. Then you just sit tight for 15 days. If within 15 days, the supplier, the person who charged your card, does not provide you a refund, then you provide a written notice to your card issuing bank that you are disputing the charge. You must do that step within 60 days of completing step 1 in Ontario. So in Ontario, you have to do this step within 60 days. And then wait 30 days for acknowledgement, and up to until you receive 2 statements from the date of notice to the card issuer for a refund. If your credit card issuer is being uncooperative or giving some kind of nonsensical response that we have already seen many times, your inquiries, then you move on to step 3. At that point, you give a notice to your credit card issuer that you are clawing back the money, and that's what you do. You just claw back the money. For this third step, it is important to bear in mind that it also involves stopping to use the card. You don't want a situation where you keep changing balances there, because that way it becomes unclear or hard to track what part is actually a legitimate amount owed to the card for purchases that you make down the line, and what part is illegitimate, including illegitimate interest charges. It goes without saying that because you don't owe the money that you are disputing, you don't owe the interest for it either. Just bear in mind, this 60-day time limit in step 2 is very important to observe in Ontario. This is something specific to Ontario. Quebec has a similar provision where you have to move to step 2 within a prescribed number of days from the day that the time to issue a refund expires. So let's now look at how this works. We have here 4 steps, and we are going to go through each of them briefly to make sure that it is clear. At step 0, we are checking eligibility. In Ontario, there are 5 conditions that you have to check. Whether it was a consumer agreement. Section 1 of the Act, which you can click here right away and it is going to come up, is defining what is a consumer agreement. So if you for some reason it was not a consumer agreement for whatever reason, then this would not apply. Next point is whether you or the supplier were located in Ontario at the time of the transaction. So you don't have to be in Ontario yourself, and you don't have the supplier to be in Ontario. It's just that one of the 2 of you have to be in Ontario. The third point, which is unfortunately when it comes to such charges, it's exceedingly easy to meet, is the requirement that you paid more than $50. And the most important practical requirement is that it has been more than 30 days since your scheduled departure. And last, which is kind of a common sense, is that you paid with a credit card. If you paid with a debit card, you can still complete step 1, but for steps 2 and 3, you will have to resort to other avenues through Ontario law. So step 1, you can still cancel the contract, and the card issuer, the supplier, still has to issue you a refund. That's under Section 96 of the Act. But in terms of the next steps, steps 2 and 3, they are based on a credit card transaction. So let's look at the cancellation of the contract. In this step, what we accomplish is we give a formal legal notice, sometimes called consumer notice, to the supplier that the contract is canceled because they failed to perform, and then request a refund. We can do so if the flight has been canceled and it has been 30 days since the originally scheduled date of departure. We need to send it to the company that charged your card and whose name appears on your statement. So make sure that you check your credit card statement. It happened just recently that we had this question in the group. And the way to do it is you check your credit card statement and you confirm there who actually charged your card. That's the person whom you need to send this notice. Under subsection 92 sub 3 of the Act, you can give the notice either orally or in writing. A notice in writing is deemed under the law to have been given when it was sent. If you want to send a letter, which is always a good idea, then you should use the address provided on the contract or the registered business address for the supplier. Make sure you have a proof. If it was something in writing, then you can have a signature, for example. If you provide notice via oral means, make sure that you record your call. We have a nice essay here, a nice short article that explains your rights to record your calls. In Canada, you don't need to get permission from other people to record your calls with them as long as you are a party to the call. And what we have here, which is something that hopefully we are going to develop further, is a letter template which takes you to the shared Google document for the letter that you can send as the cancellation notice to the vendor, to the supplier. That is it does take some time to load. And you can see here that there is a template here. This is the letter that you can send in step 1. In terms of step 2, let's see how we move from step 1 to step 2. So first you send your step 1 notice. Fine. What you do next is you have to wait 15 days. So let's look back at the overview. You wait 15 days. 15 days passed. That's the time when you move to step 2. In step 2, you are giving a notice to the card issuer that you are disputing the charge and that you are exercising your right under the Act. So in step 2, it's not about asking them a favor, not about asking them to please be so nice to give me back my money. Rather, you are asserting your right to a chargeback. in step 2, you do it if you didn't receive the refund within 15 days. The notice must be sent within 60 days of completing step 1. So within 15 days, within 60 days, that is 15-day period from step 1 has ended. And you need to send a letter to the card issuer. Use the address provided on your current credit card bill. And it's a very good idea to send it by registered mail to ensure that you have proof. We also have a template for Ontario for a letter that you can send. There is even a concrete example here for how to calculate the timelines, and we have a date calculator that you can click on that will help you with the date calculation. After you send this letter, you wait 2 billing cycles. After that, you notify your credit card company that you are clawing back the disputed amount. Clawing back means 2 steps simultaneously. On the one hand, you pay only the balance on the card minus the disputed amount. So if the disputed amount is $1,000 and you have a $1,500 balance, you pay only $500 and you inform the card issuer in writing that you will not be paying the disputed amount and request the card issuer to take you to court. This has to be sent by registered letter. That is actually a requirement under paragraph 79C of the Credit Business Practices Regulation. It's a federal regulation. And you send it to the address provided on your credit card bill. We have a template for this letter as well. Last but not least, you may be hearing all sorts of nonsense about, oh, well, we don't have to do this because blah, 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 you signed it here, there. The answer is simple. Under Ontario law, and most provinces have similar laws, under Ontario law, they don't get to choose what provisions of the Ontario law apply to you. The protection provided under those consumer protection statutes cannot be contracted out. There is no way for them to say, oh, well, actually, you waive your right. Those are not rights that you can waive. So regardless of what the contract says, regardless of what you signed, the Consumer Protection Act still applies. And you need to remember that if anybody is trying to tell you otherwise. I see here a question from Mayor Niku as to whether email or mail is better. It's a tough one. It's a tough one because on the one hand, email is faster. On the other hand, with mail, you get more certainty as to what has been delivered at the time of delivery. So I would say that probably sending both is the best practice, but I would not prefer one to the other. I would really decide it kind of based on the circumstances, based on what works best in the circumstances. If you have a way of sending the email with clear proof that your email was sent, I would probably be sending it by email. But following up with a letter is also always a good idea. So, overall, I would say in our legal system, fax is quite great, even though you may not have a fax. Fax is great because with fax you get a confirmation sheet, a transmission sheet. In some cases, the law is clear, and the registered letter, that is probably still the best way to go. Any other questions about statutory chargebacks so far? I'm not hearing any so far, but if there are more questions, we can come back to that. The last topic for today's live air passenger rights update is what happens if you booked a flight with vouchers and that flight is cancelled. Generally, that brings us back to the same situation as if when your original flight was cancelled. So if your vouchers were given for a flight that was previously cancelled by the airline, then the cancellation now means that your original deal was not delivered. If you look at even the more conservative guides for even the internal chargebacks by Visa, you will find that they recognize that if the supplier fails to deliver the services contracted after you agree to have a rebooking, agree to some kind of alternative solution, alternative resolution, then you still have chargeback rights. So I would treat, for all legal purposes, the situation, personally, if it were my case, I would say, well, we agreed to reschedule the flight, so then we have a new performance date, and if that is not being not being delivered, not being performed, then for all practical purposes for a chargeback, we are looking at a same situation as if the flight would have been booked originally for that new date. So for example, if I had a flight, say, to Budapest and for April, then the flight is cancelled. If someone accepted a voucher, then they rebook a flight for Christmas for December to Budapest. Now that flight is also cancelled. Then I would proceed the same way as if the flight would have been booked for December to begin with. So the 30 days for the statutory chargeback would start on the date when the flight was supposed to operate but didn't. I would also try in that situation to go perhaps first through internal chargeback, because it's a quite clear-cut situation. You paid good money, they cancel your flight, you were given vouchers, you rebooked, they again canceled, so you are still in a situation that you paid money and you got nothing in return. There's two questions that I'm going to answer. What is the address for TD Visa? It's a post office box. How do we send it via registered mail? My understanding is that there is no difficulty with sending registered mail to a post box type of address. There is no problem with that. It's actually perhaps even better that way. Probably there will be clear verification of stuff being sent because it goes to a post box. The other question is there a time limit to a statutory chargeback? My understanding is that there isn't. There could be possibly some issue with statutory limitations, as you know, 2 years, but even that is not that clear. So it has never been tested, but what is quite clear, and I can tell you that for quite certain, is that the 120-day limit that most credit card companies try to impose do not apply. So that 120-day limit does not apply to statutory chargeback, because for a statutory chargeback, for example, in Ontario, the 60-day, let's just go back to have a look again at how that works. So for in Ontario, the 60-day, here's an example. So suppose that on November 1st you send a cancellation letter, then on November 16 the time that was a deadline for a refund, and then the 60 days starts running. So the 60-day limitation actually starts running only at a time that after you send the cancellation letter and 15 days have passed since then. So until such time as you send the cancellation letter in Ontario, the time limit that is prescribed under Ontario statute does not start running. In other provinces, my memory is that Quebec has a somewhat similar system. So you also have their 15-day and then 60-day type of setup. In BC, let's have a look at BC guide. In BC, my recollection is, and I hope it's correct, in BC there is no such limitation actually. So when you look at the overview here, they have to provide a refund in the 60 to 90 days, but in BC there is no even a 60-day limitation for how soon you have to proceed to step 2 after step 1. So it's a universal answer to any kind of claim by a financial institution saying, well, you are past the 120 days is, well, I'm not past that because this is your internal rule, and your internal rule doesn't override the law. The law says I have this right to a chargeback, and this is again where Section 7 in Ontario comes into place. That was a discussion we had about the right being absolute. So the right cannot be waived. Let's have a look at it again. Nothing that is in the act can be waived because such waiver would be void. So Section 7 sub 1 says the substantive and procedural rights given under this act apply despite any agreement or waiver to the contrary. So whatever the credit card, bank, whatever has in place, that is at most something private between you and the credit card company. Therefore, pursuant to Section 7.1, if it has the effect or purported effect that it would limit your right under the Consumer Protection Act of Ontario, it is simply void. It doesn't have the capacity to affect your rights. There are more questions here. If a credit card issued outside Canada, for example in Dubai, credit card now cancelled since purchasing the airfare. It's a very tricky question. I'm not familiar with the laws of Dubai. It would be very hard to deal with that. It would raise some problems. Practical terms, I would just not pay the disputed amount and tell the credit card, no, this is not legitimate. But it may or may not be appropriate under Dubai law. And the question is to what extent the law would apply. If you are residing in Ontario and say you use a kind of card, it would be an interesting question whether the law would apply. I would not want to go into that. It looks like a very, very niche question. I haven't researched it properly, and one of the things that we try to do is do our best to provide accurate information, so I don't want to comment on that. Second question here. Why do this? The government will be giving bailout that will force airlines to refund passengers. Airlines and tour operators may blacklist you if you do a chargeback. Okay, Shelley, they have no right to blacklist you and they have no way of blacklisting you. Doing a chargeback is a legitimate way to exercise your rights. The bailout may or may not be coming. The terms attached to it may or may not eventually require refund to everybody. We have seen that this government has not been doing a great service to consumers. I would not be surprised if they were, again, having something full of loopholes, full of excuses for the airlines. And there is one simple reason why you should do it. It's not the airline's money, it's your money, and you should not have to wait 6 to 9 months, perhaps like in WestJet case, they are promising a refund in 6 to 9 months, to get your refund. You should have already been receiving your refund many, many, many months ago, and those airlines are stealing your money. The way to think about this is that you are taking back your own property. It's like your car. Someone, while you were asleep, someone came to your house, broke into your car, took away your car, and left it at the other end of the city. You hear where it is, you go there, you have the keys to the car, it's your car, and you take it. You don't need anybody's permission for it, you don't need any kind of justification for it. It's your property, so you take it back. Another question, how long can you wait until you start a statutory chargeback? I understood the question, Jeanette. What I was telling you is that you don't have to start a statutory chargeback right away. There is no limit of how long after so many months you cannot do it. Personally, I will start it as soon as possible. It's quite clear now that the airlines are refusing to comply with their legal obligations to provide refunds to passengers. The airlines are hell-bent to steal our money. So therefore, I would say the sooner you do it, the better. If the credit card company is willing to cooperate through internal chargeback, that may be an avenue. But the one important thing to remember about statutory chargeback is that the credit card company does not have a discretion. It's not like a negotiation. It's not like the internal arbitration process where it goes to an internal arbitration and then they decide. No, it's the law, and you provide them just some very basic facts. If you look at the template letters, you just have to tell your credit card company when was the service supposed to be delivered, what kind of services they were, when did you cancel, some very, very basic facts which we outline in the letter template. Once that information is given, they have to reverse the charges. They have no discretion about it. Any other questions about the stuff that we have been discussing today? I'm not seeing many, but I know that there is a bit of a lag, so I'm tempted to wrap things up soon, but still would like to give a bit of time. Actually, in the meantime, I should mention that I am looking for volunteers who are willing to spend the time to read through what we already have on our website for the Ontario and the British Columbia chargeback guides. So it is still a work in progress, but I'm sure there are typos. I'm sure there may be some links that don't work that they are supposed to be. There are goof-ups almost in every document one comes up with. So I would most warmly welcome some help. If anyone feels like they are able to, I would be grateful for that. I'm not hearing any more questions, so I'm going to just ask the team, how are we doing? Should we still wait a little bit, or should we call it a day? Oh, another question here. What is the timeline when this information becomes live on the website? Brian, it's a question of how many sleepless nights I can do. The content has already been written for all provinces. So if you're looking for just the guide in some less elegant form, certainly it's already available in a Google Doc, and it has already been posted, the draft, in the Facebook group. So if you go under announcements, and there is a top post, one of the items there under, I believe, internal chargeback, the next thing will be the statutory chargeback. So if you need the information right now desperately, you can find it there. If you are in Ontario or BC, these are the two provinces for which the guides have already been posted, just the link is not public yet. So if you, Brian, after this, reach out to me, and I will be happy to share with you the link if you are willing to and able to help with proofreading it, with critiquing it, just making sure that it's really clear to everybody. Because after all, what we are creating today is hopefully going to help people down the line in many years to come. Statutory chargebacks are not going to go away. They are an important procedure, important consumer protection measure, and actually they should be further developed. Ideally have a uniform statutory chargeback across Canada. I am not hearing more questions now, and I have been yakking here for close to 50 minutes. That's pretty much the time of a what they call a 1-hour lecture. So I think we should call it a day today. Thank you very much for being with me, and take care of yourself. Make sure to keep physical social distancing and no partying. We can party once this COVID is over, once we all have gotten back our money. That's the time to party. Right now we need to take care of ourselves, take care of our communities, and as our premier here in Nova Scotia said, stay the blazes home. Be safe, take care. I will see you in a couple of weeks for another update.